Hello, everyone. Welcome to the Trade Policy Exchange webinar on the topic of computational law and digital trade, envisioning the legal technical convergence. My name is Nathaniel. I'm a research officer from the University of Oxford, and I'll be your moderator for today. This webinar is being hosted by the Trade Policy Exchange, which is a multi-stakeholder platform that shares ideas and connects trade professionals aiming to promote an open debate on trade policy between international institutions, governments, civil society, business, and academia. So in essence, the Trade Policy Exchange promotes a diverse range of voices, as you'll see today, and aims to showcase fresh ideas and faces with a strong commitment to diversity and gender equality. I'm joined here today by three very knowledgeable panelists, as you'll see, and together in the next hour, we will explore key questions on the topic of computational law. And through that, I hope that we'll all be able to benefit from their insights on the topic. So on the panel today, we have Jason Grant Allen, who's the director from Singapore Management University, the Center for AI and Data Governance. And we also have Craig Atkinson, who's the trades development specialist, and he works with the United Nations, the WTO, and the ITC. We also have on the panel Megan Ma, who is the assistant director at Stanford University, the Stanford Center for Legal Informatics. So I'm just going to set the scene a little bit for the discussion that we're going to have today, and give the definition that Nathaniel Love and Michael Genesereth gave in 2005. And for those of us who are new to the subject, computational law refers to an approach to automated legal reasoning, focusing on semantically rich laws, regulations, contract terms, and business rules in the context of electronically mediated actions. However, also according to this definition, current computational tools for electronic commerce fall short of the demands of business, organizations, and individuals conducting complex transactions. Now, in response to this challenge and the complexity associated with cross-border transactions, computational law has potential to bring coherence to the digitalization of international trade. Now, jumping off of this, I just want to get into the first question and ask the panelists today that how can we further conceptualize computational law? Now I'm going to start with you, Craig, and then we can move to Megan and then Jason.
Yeah, thank you, Rotendo. And I just want to say thank you for moderating today, and then also to the Trade Policy Exchange team for giving not only a platform for new voices in the trade space, but also new topics such as computational law. I also have to give a really special thanks to our esteemed panelists, Megan and Jason. They're big minds in the computational law space. We're a global community here today, spanning kind of almost all the continents. Yeah, to get to the question, because we have a tight timeline and a lot to discuss today, it's really difficult to specifically conceptualize computational law. It's like one of those questions, the concept is inherently tied up in the idea of what is law. I don't really want to get too philosophical today because we're really kind of looking at an application of computational law, which is in digital trade. But I wanted to say that CompLaw or computational law is a contested term, and a lot of the work of scholars has been on to actually define the field itself and sort of what its parameters are. But I really want to riff off of another definition given by Michael Genesereth of Stanford University from 2015, that computational law involves the codification of law in precise computable forms and the mechanization of legal reasoning. And this can really be for the purposes of legal analysis or for operations, and it's often involving compliance for the latter. But for me personally, CompLaw is about expressing rules in the form of algorithms so that they can be more easily understood by humans and automated by computer systems, often using data as an input. This is sometimes referred to as law as code or law as data, or in practice under different movements, such as the rules as code movement, or alternative movements such as the rules as data movement. But stepping back from this, I wanted to share a few observations from my research. So I'm just going to share a few slides right now, if I can. So just 1 second here. Okay, so up front, I just wanted to kind of run through a little bit of terminology that might help in the later discussion. So one of those conceptual areas that can help us understand computational law is the difference between digitization, digitalization, and digital transformation. So digitization typically refers to the conversion of analog sources, often paper-based, of data and information, sometimes tasks, into electronic forms that can be processed by a computer. Different than that, but following a phase of digital transformation, digitalization is the use of electronic data sources, the outcome of digitization for the purposes of process improvement, such as automation. And digital transformation really describes an organization or system-wide change related to the use of digital technology. So I wanted to kind of touch on 3 different areas that are of relation to each other. There's a bit of an analog here, but it's not one for one. But the definition of an algorithm as per Kowalski from 1979 is that an algorithm is made up of 2 components, a logic component and a control component. In the field of linguistics, particularly semantics, there's 2 different branches that have relevance and sort of similarities to the way an algorithm is described. So one of those is formal semantics. This is usually looking at syntactic and logic structures in linguistics. And there's also lexical semantics, which focuses on the meaning of words. And then thirdly, in the law and business policy realm, rules can really be defined in many different ways, but one way of thinking about rules is 2 different subsets of rules. One being the behavioral rules. These are sort of the logic of rules that involve imperative verbs, must, may, and should, and definitional rules, what is something. And definitional rules can be inferred through what's called an inference rule. So as an example, in the trade space, you could have a tariff rule expressed in natural language with a logic, but each part of that rule could refer to, for example, standardized nomenclature, such as the HS code for types of goods, as well as country codes for a variety of jurisdictions. And this also relates to the idea that there's inference rules. So for example, you can determine which tariff rate applies based upon a schedule of tariffs. So that's sort of a run through some underlying concepts that relate to the definition of computational law, and that's just my perspective.
Yeah, thank you, Craig, for that. Jason and Megan, would you like to jump in as well?
Yeah, happy to kind of jump into the topic. And, I'm glad that Craig, and thank you again so much for kind of the invitation to be here. And it's nice to be on this panel because both Craig and Jason are familiar faces to me. We are old friends, so it feels like sort of a little bit of a reunion. In terms of kind of how I see the conceptualization of computational law, I'm really glad that sort of Craig brought up the definition that Professor Genesereth had created. I work with Professor Genesereth, so I hear about the mechanization of legal reasoning as sort of the definition that he constantly refers to. For me, computational law is really debunking this idea that natural language is sort of the one paradigm or the one medium through which law is communicated. I think the idea of computational law is primarily, rather than sort of stepping into law as computation or law as code, to me, it's articulating that there are different parts of the law that has a structure that it follows quite closely to logic. And so it might be a preferred medium that you can communicate the law. There might be other mechanisms such as comic contracts or, using other ways of expression. And I think that's really this idea of computational law, is that there are certain parts of the law that do prioritize efficiencies and precision and accuracy that could depend on kind of existing tools that are more, conducive to computation. And that is kind of what computational law sort of represents. There are other areas that might, be more conducive to legal informatics, which is another area where you can use analytical tools to unpack existing concepts in the law. So I think, again, sort of computational law is opening up this idea that law doesn't have to rely necessarily on natural language, and that in many cases, natural language has been somewhat of this double-edged sword. And so computational law sort of allows areas where natural language has had somewhat of a bit of a stickiness. It's it's enabled disputes, for example, or, had led to inefficiencies. And instead, kind of these areas we can allow them to kind of lend itself to computation.
Jason?
Thanks. Thank you, Rutendo. And I just echo everybody's comments. It's really lovely to be here, and thank you to Trade Policy Exchange for the invitation. And it's lovely to speak after Craig and Megan as well, because we've had many conversations now, actually over a few years, and I always learn something when I interact with them. So I'll answer just very briefly in terms of some very personal reflections, which is, zooming out, and we've heard, I think, really competently what computational law is. We know it's, a bit fuzzy or contestable at the edges, but we know what the core of it's about. And for me personally, I kind of have this tension, between, on the one hand, nothing new is there's nothing new under the sun, and we've been automating, things like contract formation and execution and performance like for decades now. And on the other hand, thinking, but are we on some sort of actually civilizational level inflection point? And it's always hard to know, because we only ever have our own lived experience as the frame of reference. And our frame of reference, I think I got my first sort of PC at home in like 1994. So in the very early days of the internet, and it's just gone totally ballistic since then. So, some of my interests are a little bit esoteric. I try to keep squarely focused on practical problems in my research, but I've spent a few years stomping around in legal theory as well. And, viewing at it, Craig asks rightly, what is law? And however you answer that question, law is certainly a conventional practice. It's something that we kind of make up as humans as we go along. And the way that we do that is through language. Like law really, the fabric of the law, like the rest of our social world, is sort of woven with language and different types of what linguists call utterances, and speech acts and so forth. And changing the language that we use to do law, I think for me is incredibly exciting, and has to hold the, has to be pregnant at least with potential for very interesting social transformation. Especially when you're looking at networked societies, on an unprecedented scale. So that's what computational law means for me, is a chance to geek out and think about where things are maybe going.
Yeah, thank you all for your insights on that. That's very interesting. What you've all said, especially about the relationship with law and language, and how computational law is kind of like changing or expanding that rather. And that's very interesting. Now, just building up on those definitions, I think my next question is, what are some of the approaches to represent legal and business rules in computational forms? I'm going to start again with you, Craig, and then we'll go to Jason and then Megan.
Yeah, so wow, I think that's a really good kind of segue from what Megan and Jason just described, because that's really the big challenge that computational law tries to address. We're living in this world and this reality of transacting and interacting, where now we are using information and communications technology to mediate these interactions and transactions. but we've typically used natural language in the past, like the idea of text as the technology. And as we move past that, we got to think about what are the ways that we're trying to approach the representation of these, let's call them these normative rules in computable form. So this has been approached by different people from different disciplines in a variety of different ways. So, and one of the interesting things is that it actually is bound up a little bit in kind of the branches of law. So public law has kind of seen its own adoption of different types of approaches, where private sources of law, the idea of like smarter computable contracts, has kind of evolved on its own accord. And so in considering that, there's a variety of different ways that we can look at these approaches. So one of them doesn't even really involve computers. And this is really just to look at that technology of text and really look at particularly unstructured natural language and try to give some coherence to it. So there's this idea of what's called controlled natural language. So this can be a step of taking unstructured natural language and giving it some practicable form such that it could be more useful for maybe people to operationalize, but also for machines to operationalize and apply. Another approach, which is kind of at the intersection of traditional programming and law, is the idea of using conditional logic. So this is the idea of if-then type expressions. And this has actually been explored recently through the government of Jersey's computer readable legislation project, as well as in practice through the European Commission's rules of origin self-assessment tool. There's a big debate on whether or not this is appropriate. And I'll say a few more words on different approaches, but I think this is where Megan and Jason are really going to want to comment. There's another approach that's really kind of called the idea of programming languages for the law. These are often taking the form of what are known as domain-specific languages, or DSLs, or there's even computable contract languages. And another approach that's a little bit closer to my heart that I've been working on is sort of a combination of using controlled natural language to sort of shoehorn the logic of natural language expressions into tabular data structures, such that those are agnostic to any particular programming language and can therefore be used across systems, because there's this issue of, well, we might not all speak the same natural language or read the same natural language, but then what happens when we have disparate programming languages and disparate systems? So I guess kind of to sum up, regardless of the technique, I think there's like a few major considerations to take into account. So one is how appropriately is the intent of maybe a normative rule represented using a particular approach? And then is that approach auditable by the people that actually are, who are expressing that intent initially? And then maybe lastly, what is the compatibility of this expression across different systems? This kind of gets into the idea of like the so-called digital islands issue. So those are some different ways to kind of approach a similar problem of text direction or normativity, and the variety of approaches that can be used.
Yeah, I think if I could jump in from this, and thank you again, Craig. I think that was incredibly comprehensive, all the different approaches that we've seen. And I think in hearing your discussion, at least my initial reaction is, wow, there really are a lot of languages out there and a lot of different ways in which we are representing the law and representing legal rules and business rules outside of natural language. And the kind of gut reaction I have here, and you sort of tease that out, is what about questions about interoperability at this standpoint? Because the idea with having so many different languages, it's incredibly exciting, but the digital islands that you're referring to, it's going to be equally problematic in the sense that you sort of created your own United Nations of languages to represent various legal documents. And at the end of the day, would people default back to natural language just because that is the common language that people can communicate through the law. And I think it sort of defeats the purpose to an extent of wanting the law to be more accessible. Because one of the ideas behind kind of using these different formal languages or various approaches is that you're finding ways in which the law could be communicated to folks that don't usually understand the opacity of legal language. And I think Jason and I, we've had these conversations about what is the role of legal language. And sometimes we have comments about like the defense for legal language. There's kind of like historically law and language scholars, they talk about this area of the viscosity of verbiage that comes from natural language, and having natural language is sort of the foundation. And so one of the ideas that we think about sort of going forward is, do we need compilers that are able to more fluidly translate between natural language or these other representations? Or should we bring together some sort of consensus in which there's a different sort of stack that we build legal documents on? So we've seen, for example, a Accord project, they're known for their stack of natural language as sort of the interface, but there's, you know, data as the kind of modeling, and then they have also a logic to it. Is that kind of approach going forward? So that a lot of the times that we think about representation, we also have to think about the ways in which users going forward can interact with them, or if there's different components that people should be interacting with. And so that's kind of, I think, my initial reaction when it comes to representation of both legal and business rules is, you know, how are we enabling more and more folks to actually access and understand these legal documents? We don't want to create more layers of opacity or more ways in which it becomes inaccessible. Or is it that we, you know, we defer representations to certain systems, that we're using a specific language because we want it to be machine executable in certain ways? And I think Craig touched upon like intent. I think the more languages that we have, the more likelihood that we have this idea that more than one intent can appear. And so how do we kind of reconcile some of these interpretations? And so those are sort of some of my gut reactions when I think about representing the law and legal and other sort of legal business rules, all of that kind of ecosystem.
Again, it's so fun to follow these guys. And I think, you know, Craig's given that breakdown of the various different approaches that we can take to the core problem, which is that we have these legal propositions, and they're propositions of, you know, of sort of deontic sort of modes of prohibition or obligation or permission. And we've got a logic of action in there as well, because it's about doing things. And we need to somehow take that from, you know, English or legalese and convert it into some kind of data structure. And I'm gonna riff on Megan's comments a little bit, I think, too. You know, obviously, one approach that we've all had shoved down our throats over the last few years is blockchain. And one approach to doing computational law is to you know, use these smart contracts, which are kind of scripts. So little bits of code that sit on the application layer of a blockchain, and they change the state of the data structure conditional on the, you know, based on sort of conditional logic and sort of if-then logic. And if the state of the world changes, and that world might be the state of another ledger, or, you know, the action of a participant in the network, then, you know, we'll change things. And the result of that is that, you know, maybe Craig transfers to me like 0.001 of a Bitcoin or something. And generally these things are designed to be tamper-proof, or at least tamper-evident. And they're kind of legally agnostic, or maybe a little bit anti-legal, in the sense that in the early days, at least, we didn't really want these to interoperate with the law very much. You know, and so Megan talked about interoperability between the different languages, but there's also this sense of interoperability with the incumbent legal system and the sort of wet, messy, natural language that it works on. You know, do we want these computational legal structures, or these computational structures, to interact with legal doctrines like mistake, for example, or in law, frustration, different legal doctrines that mean that maybe we don't want a contract to execute as it was intended to at the start. And so I guess that's the thing that I'd add to this question in terms of approaches to doing computational law. That's going to be a major difference of approach. Is do we want it to interoperate with traditional legal doctrines, also traditional legal institutions? And as Megan said, we have this language stack, and the default language or medium of argumentation, and therefore of further downstream dispute resolution, is natural language. Like, we'll go back to arguing in messy legal English about whether the code, ran as it was intended to or not by one or both parties. And so there's this back and forth kind of translation, and it's this wondrous thing where we're going from, the natural language thunk in the head of a developer or of the client, then express the developer, and then in a whole array, actually quite a stack of different sort of computable languages. And ultimately we're talking about like machine code, which actually correlates to physical locations and electrons moving around like a silicon semiconductor. So on the one hand, we have the alchemy of the human brain, which is also, electrochemical, but and then on the other hand, we have this this very dry, cool technological process in a semiconductor. It's an important question how we want it all to interoperate. And as a lawyer, I obviously have a bias towards the law for all of its imperfections. But I think that's the really operative question.
You all raised some very interesting points. I was very interested to hear about the idea you brought about conditional logic, Craig, and using programming for programming language for the law, and even what, like both Jason and Megan, what you spoke about with regards to interoperability. I think that's going to be a big thing going in the future. It's already a big thing now, really, trying to understand how that will all work. So now just picking up on that and going a bit further now, I'm going to start with you, Megan, on this one, because of what you were talking about with regards to people accessing and understanding legal documents that also can be machine readable. Now, when I hear something like this, I think more of AI. And now my question here is, how can or should AI approaches like, large language models, for example, be considered? And is there a potential role for other technologies in this?
Yeah, I mean, that's a great question. And I love this question because the sort of onset of ChatGPT in November of 2022 was incredibly disruptive. And I think all of our panelists can agree that it kind of rocked the boat a little here. And especially for all of us who have worked for years in the area of almost symbolic AI and representation and knowledge representation, our idea here is, well, we've struggled for a very long time trying to translate natural language into these other sort of languages and other ways of representing the law, when I can just throw my contract or throw any piece of legislation into a large language model. I can throw it into ChatGPT and start asking questions about it. And so this idea that you're raising, Rutendo, here about accessibility and what we really want from our tools is really at the forefront of this question of what are these other approaches. And a lot of what we started to explore is large language models, this neural approach, prepared to sort of replace the symbolic knowledge representation approach? And fundamentally, I would say no. And I think that there's a lot of ways in which the two of them can find sort of hybrid possibility and an ability to sort of collaborate together. And why I think about that is we started to experiment for a bit with using large language models in the area of immigration and other of these sort of standard forms. And what we noticed is that without an ontology and without actually understanding the relationships of entities between one another, actually just throwing the model and just throwing a natural language at this model, it has no actual model or understanding of the world. And so it's creating and it's sort of enabling almost this fact hallucination because it's trained to provide an eloquent answer to you, but it doesn't have these clear understanding of relationships. And at the end of the day, there's a lot of parts of the law that require necessarily this implicit knowledge and an implicit understanding of the relationships between parties. And so I think that with thinking about large language models and thinking about sort of knowledge representation here, a lot of what we've been trying to explore is, could large language models act as almost an accelerator or an ability to scale some of the existing models that we've built in the symbolic or the knowledge representation space? So when we talk about computational law, making legislation computable, making contracts computable, we've created these robust models. Can we feed those instead into large language models so that the efforts, those manual laboring efforts that we've done to translate, can be vastly accelerated, that we can use those large language models to scale? The other idea that we've thought of with large language models is this idea of natural language generation. So using kind of large language models to kind of very coherently explain these logical outputs. And so a lot of these interactions of systems, a lot of these languages, even if they've kind of really struggled to an extent with being very easily readable or easily accessible for those who don't have a mathematical or logic-driven background. And, you know, to an extent, a lot of these languages, especially their semantics, it's actually not too difficult to read, but even that extra effort, to be honest, from a mental standpoint, people still default to natural language if we were to talk about default languages. And so a lot of what we see with large language models, at least at Codex or Stanford Center for Legal Informatics, is how can we actually take this incredible sort of high level analytical work that we can perform using these symbolic models and actually have a very easily explainable method of communicating it. And so those are some ways in which we find kind of intersection between large language models or AI, broader AI approaches with the symbolic or computational law element. But, you know, at the end of the day, these models are evolving at lightning speed. We kind of haven't seen that level of comprehension. And to be honest, a major inflection point for me and at our center is we typically like to ask common sense questions like, how many legs does an apple have? And prior to ChatGPT, prior to this current era of models, the models would always answer with, an apple has 4 legs. But that's because it's trying to understand the similarity of language or the vectors, right? It's a vector comparison here. But for whatever reason, well, there's kind of lots of guesses and hypotheses of how ChatGPT evolved. But ChatGPT instead answered as, an apple is a fruit, therefore it has no legs. And when it answered this was a major inflection point for a lot of us researchers here. And so again, like we find ways in which large language models and symbolic logic can find intersection and find overlap. But for now, it still remains left to be told kind of what we can do in the future of computational law and large language models.
Yeah, that sounds very interesting. I'm also interested to hear what you think, Jason, and then Craig as well.
Sorry, I'll unmute myself. Thank you. This is, I think Megan's absolutely right. I certainly feel, I mean, I followed, you know, GPT, you know, earlier iterations of GPT before the launch of ChatGPT, and I kind of played around with it. I think the scale and the speed of the uptake, and then some of these surprising capabilities, and then, you know, the announcement of GPT-4 with, you know, potentially even more capabilities has certainly kept me and my colleagues at my center as well on our toes. So, you know, I'll mention. I mean, I mentioned in my previous comments, you know, blockchain and distributed ledger technology and so forth as well. I think, you know, taking note of this big broad question, you know, about the role of symbolic logic versus, you know, these large language models, and are we going to see kind of mashup. We've got, for example, a Wolfram Alpha plugin for ChatGPT, which is wonderful. And I'm really glad that Megan mentioned ontology, because that's the esoteric interest of mine, is really social ontology. And it's that the objects and the entities that make up our social and economic world, like corporations and money, these are all things which are created through declarative speech acts. 10 people should count as a corporation, and the currency of the United States should be the dollar, and it has 100 cents. There's nothing naturally occurring about dollars and cents. They're so it would be quite nice if these large language models were actually operating with the benefit of an accurate ontology of the human world that they're now bursting into. The role of blockchain and DLT, I think, has been a little bit mixed. It's done a lot to drive awareness of computational law. It's brought computational law ideas really into the limelight over the last 5 years, especially. There have been people working on this, for decades, largely in the dark. One thing that I should have mentioned in my previous comment as well, is in terms of design approaches, is the difference between the Ricardian contract, which is a computable sort of data structure, which is also meant to embody a legal contract, and then this sort of blockchain smart contract, which is meant to be extra legal and not necessarily interact with the legal system at all. The Ricardian contract is from the 1990s. Actually, the smart contract term was coined in the 1990s too. This is all, pre-blockchain. We're talking about, the cryptographic, parents and grandparents of the Bitcoin blockchain. So blockchain and DLT in that community, I think, have done a great service to bring computational legal thinking into the limelight, and to raise a lot of interesting questions about computational law. I think there's also a role for other approaches based on symbolic logic and formal languages that are not necessarily tied to a blockchain data structure. And I think they have an important role to play, especially in things like trade and contract automation. And I think, we'll see increasingly a marriage of the two. I think increasingly lots of people will be using something like GPT, for example, as a co-pilot to write their code in Solidity or Ergo or any other smart contract language, even though they might not be a coder. So you might say, ChatGPT, I need some code to, give me an arbitration clause, or to automatically deduct, 10% of the purchase price if the sensor in the container fluctuates more than 5 degrees centigrade. And a lawyer might be able to do that, even without a lot of prior coding experience. So I think there's a role for various sort of technologies and various approaches.
Yeah, and I wanted to expand on both these very well described responses, because I think Megan nailed it with this issue of the drudgery associated with a lot of these approaches that involve extracting the logic from very large documents, legal texts, if you will. Legislation is long. Regulation is maybe a more precise articulation, more practicable in many contexts, but kind of bringing the conversation back to international trade, these are some of the most cumbersome documents that exist. I mean, printed out, some of the recent regional trade agreements are as tall as a small person in terms of the amount of pages. And so when we look at the systems that would be used in international trade, I know this is kind of getting into the next question, but I'll kind of keep it on this area of where maybe something like an LLM or other maybe statistical type of approaches can come in and intersect with maybe more of the symbolic approaches. What we can do here is we can look at finding where the rules are in a very, very large document and in relation to the beautiful thing about trade is there's a number of ontologies that exist that relate to entities, that relate to, as I described before, in that brief example for a tariff, goods have a classification system, the HS system, that is very unique as compared to any other jurisdictional approach to classifying any object in the real world. And so when we look at these trade agreements and we try to figure out how do the rules get from these very, very large documents in using maybe a symbolic or approach to express the logic of obligation and prohibition, the idea of what defines a rule, from these large documents into a system that would use it, regardless of the discussion around interoperability, et cetera. It's just a it's a drudgerish process to even start fathoming this. And there's been a lot of work on the idea of text as data, which is sort of the analysis of text as a representation of data, and maybe there's similarities between trade agreements, but there's not really been any work to kind of coherently digitalize the obligations and prohibitions found in one of these large emergent or existing agreements. So I think something like an LLM can be a bit of a game changer, especially when we're just considering the text as technology and the idea of natural language having some boundaries in terms of controls for its normativity. But also, though, when we take this into account and like, let's say we have these expressions, just kind of riffing off what Jason was saying, then I think some of these other technologies, I don't think blockchain or DLT or any distributed, decentralized technology is like, the thing this is the one game changer. But I think when we look at an assembly of these different approaches and technologies, typically when it comes to the issues of maybe event-driven trust in a contextual relationship, I think that can be something that really solves some of those problems related to, multi-entity kind of relationships and transactions. And in trade, that's a common problem, whether it be in the trade finance space, which we've seen a lot of development of these types of solutions. But the problem remains is that there's a lot of work that needs to be done. And so I think some of these approaches, whether they be AI, LLM, more old school machine learning, or more distributed, decentralized type of approaches of nodes and networking, and cryptographic methods. I think the assembly of these could be very powerful for enabling computational law, not just in the sense of how authoritative or how accurate its representation is, but how it can actually start to kind of fill in some of those gaps that exist in terms of, okay, we have this problem that's always existed since ancient traders when it comes to cross-jurisdictional relationships. But, it's still not necessarily law per se. I mean, I don't want to get into that philosophical discussion again, but I think it's really important to kind of talk about these technologies, how they fit in, but separating that from the hype cycle and actually kind of looking at these approaches and understanding how they can be woven together in a very coherent way. That's not just, we have AI or blockchain in the name of our company, fund us, and we're going to change international trade. I mean, we've already seen the last hype cycle has kind of run its course. So I think these are all really important things to kind of take into account. And I really appreciate all these responses, because I think this is the conversations. These are the type of conversations that we've had personally, but it's really good to expose different domains such as international trade to these kind of niche discussions.
Yeah, thank you for that, all of you. I just want to come back to the points that you were raising about international trade. But before I do that, just want to encourage our participants, if you have any questions for the panelists, please post them and then we'll try to get to them at the end. We might not be able to get through all of them, but then we'll try to go through as many as we can. So please post that as you think of them and as the panelists keep talking and giving their insights. Okay, so now I'm going to come back to you again, Craig. Just coming back to the idea of international trade. So what do you think are some of the potential trade-related use cases or systems for computational law?
Yeah, so this is a really good question because this gives a little bit more of the practical kind of perspective to how these various, let's call them computational law approaches, which is, hard to define, but where does the rubber meet the road? Where do we see the potential use cases for these well thought out approaches, and what kind of systems would they enable? So I really think there's kind of two ways of thinking about this. The first is really more broadly that I think they change contracting. We've already had a little bit of a discussion on sort of the private law aspects, or maybe the law agnostic ways that technology has been used for the way that people can contract with each other. And I use that word very loosely. But I think one of the other major areas is related to compliance. And so what we're seeing right now, particularly with the implementation of several agreements, but in particular at the multilateral level, the WTO Trade Facilitation Agreement, it mandates that every WTO member must implement a national single window system. So a single window system is a variety of different platforms, systems, and environments. They're not only used in trades, they do allow parties involved in a transaction to lodge standardized information and documents with a single entry point to fulfill, in the context of trade, all import, export, and transit related requirements, often regulatory. And if information is electronic, then individual data elements should only be submitted once. That's why it's called a single window. And really advanced examples of single window systems do have some level of automated rules and data processing functionality. But the issue exists in that, A, we don't actually know how many of these systems are being implemented in any particular way. So for example, computational law brings a bit more rigor in the way that we consider the actual expressions of obligation and prohibition. In many cases, this would be obligations of importers and exporters, in forms such that they could be used by these systems. And then another issue is that once we have, let's say, a global network of single window systems, how do they interoperate with each other? How do rules get from one single window system to another when there's a requirement, maybe in a value chain that spans different countries? And how do countries actually figure out, how do we implement such a system in a way that we're able to do so and we don't have this issue of maybe legacy systems, et cetera, as well as we have a rapidly changing environment for rules. I mean, the pandemic showed us that every hour at one point, the rules for sanitary and phytosanitary type conditions were changing. And so I think this is really important as a use case area when it comes to compliance. Then I also think that when it comes to an area like digital trade or e-commerce enabled trade, that all of the rich data that's provided through electronic invoicing, electronic payment systems can then start to be leveraged by these electronic representations of rules. And so that means that we can actually start to have small and medium-sized enterprises, for example, better participate in international markets through being able to supply the necessary data elements that would enable them to comply with international requirements and rules, but also just in the sense of like greater market visibility and understanding what is the best market to sell my products based upon the rules that exist there and the data that I have. And that's even getting back to some of the things we spoke about earlier, which relate to, natural language and the disparate natural languages we have. And if we can move to an approach of sort of a lingua franca, so to speak, I think we can kind of change the way that systems enable trade across disparate cultures, languages, jurisdictions. So I think that would be kind of me summing up what I think the kind of trade-related use cases or systems for CompLaw could be.
Yeah, thank you for that. Jason, I'm also interested to hear what you might think about this.
Yeah, thanks, Rutendo. And I'm by no means an expert on trade law. I tend to approach this question more just from the background of, I guess, cross-border commercial law. What is computational law going to mean for commercial law generally, and especially cross-border type transactions? And I think in the interest of time, I'll make just one point, and it's that when you digitalize a contract, you do a number of things. You formalize the expression of its provisions, and you potentially also automate performance of some of the provisions in it. But you also kind of make each transaction, and even more importantly, each relationship or your series of transactions with a counterparty, kind of like a data asset. And from what I gather, for example, so in a little book project I did a couple of years ago, my co-editor had started an open source project, but also a startup which developed a smart sort of legal contracting language and so on, and that was acquired by DocuSign. From what I gather, and I was chatting with the DocuSign reps at a big sort of tech fair in Singapore the other week, it looks like really they're just using it as a contract lifecycle management system at this stage. And that's a really interesting kind of data point, because if we go back to the early days of innovation in the West, and the reception, for example, of algebra in the commercial kind of city-states in northern Italy, these innovations in accounting, like double entry bookkeeping, were great because they would allow a merchant to know whether they were solvent or bankrupt at any particular point in time, even though all the ships were still out and correspondence networks were slow. There was no email. And I think, if you can imagine a dashboard with all of your contracts there, and you can see the state of the different contracts, and you know how you're doing, and you know how counterparties are doing, I think that could be revolutionary for trade as well. And Craig mentioned, for example, things like trade finance, and if we then think about incorporating these sorts of tools for SMEs, and even micro businesses, or the power of ubiquitous mobile, especially in emerging and developing economies, there could be some cool futures here for trade if it were implemented correctly.
Yeah, thank you for that. So now I just want to go a little deeper into digital trade, this being my final question, that is, and then I'll open the floor to questions from the participants. But so we all know how instrumental data has been to our age and how it's changing law, and I imagine even with computational law as well. So I just want to hear, given the importance of data in our age, how might data governance initiatives affect the application of computational law for digital trade? I'm going to start again with you, Jason, coming off of what you just said now, and then we'll go to Craig.
Thank you, Rutendo. And that's a super important question. I think, the brief answer is really, first we need to work out what data governance is kind of about and what we want it to do. And it's obviously about privacy and it's about data protection. We've seen with GDPR, these can impose transaction costs and even, barriers to things like computational law, in the sense that, we're talking about data moving across borders, and the related phenomena of things like contract automation, because this digital economy runs on a huge set of third-party dependencies, and a lot of goods and services that depend fundamentally on data and on the movement and the free movement of data. So various data governance initiatives can kind of cross-cut with, for example, the rollout of computational approaches to law in trade. And it's not just privacy and data protection, it's also things like national security and critical industries, the tendency to try to localize data. I think at base, data governance for me is really about asking when and why, for what reasons, under what conditions do we want to allow access to data, and what are the entitlements and duties, and how do we distribute the benefits and burdens and risks of that? And there's going to be different legal mechanisms to do it, ranging from prohibitions, or like we see with some forms of data moving out of China, or with fairly complex sort of compliance frameworks, as in the EU GDPR. We might have property. We might be effectively commodifying data. There might be role for tort or other sort of legal subdisciplines as well. And I think that can and will impinge on computational law in the trade context in lots of complex ways.
Yeah, I was just going to build on that because I think that when we look at digital trade, data governance, computational law, I think they're kind of interwoven and they're kind of codependent in many ways, because we have this idea that we're trying to use natural language expressions of prohibition and obligation to actually regulate data flows across borders. At the same time, computational law in many cases is attempting to use data structures to actually operationalize or apply expressions of obligation or prohibition. And then we have digital trade being sort of that transaction, that interaction that occurs across borders that's mediated through information and communications technology. So, I mean, we've seen various authors and scholars even try to, for example, model GDPR provisions using computational approaches. One of Megan's hats, of her many hats in the computational law space, is with the MIT Computational Law Report. There was an excellent article a few years ago about, is it even really possible to model, for example, data protection regulations using computational approaches. I don't really think there's one answer to any of these things. I do think, though, what we're moving towards is like a little bit more clarity on different fronts. So Jason has kind of tasked me as a kind of contributor, affiliate, so to speak, with the Singapore Management University Yung Pung House School of Law, Center for AI and Data Governance, to kind of look at a bit of this when it comes to Japan's concept of data free flow with trust, and their movement from not just a concept, but towards a institutional mechanism that will be trying to sort of pilot and create a laboratory for technical approaches to sort of realize this interaction between the legal technical convergence, sort of the subtitle of this webinar today. So I think it's like one of these areas where there's a intermingling of kind of law, technology, institutions, people, processes, et cetera. And it's really kind of interesting to see how data governance might impact, the level of digital automation that we see in trade going forward, and just interactions generally that we have across borders. I mean, there's discussions around fragmentation in the legal fragmentation and regulatory fragmentation sense, but also in the technical fragmentation sense. And there's even sub forms of these fragmentations. So it's a really interesting area. I think no one has any of the answers right now. I am hopeful that what Japan is trying to put forward might help kind of sew back some of these divisions. But time will tell. I'll leave it there, though, because I think we might have a few minutes for questions if there are any. So thank you.
Yeah, thank you for those insights. That's very interesting to hear, especially from a digital trade and data kind of point of view. Yeah, so we're gonna open it up for questions now. There's no questions that I can see right now, but if you have any questions that you want to ask any of our panelists, please just pop them in the chat, and then we'll ask them to attend to that. I'm going to just give it a few seconds to see if anybody responds. If not, then I'll ask our panelists to just, like, in a minute or two, just quickly like sum up like the key things that you want us to remember, or like your final thoughts on this subject, just as we go. Or maybe we can do that, and then we'll see if there's any questions. Then we can just come back to any questions that would have popped up in the meantime. So with those final thoughts, I want to start with you, Megan, and then we can go to Craig, and then close with Jason.
Sure. Well, I think this has been a really interesting chat. One thing that comes off the top of my mind is what we're really talking about here with computational law is kind of this toolkit that we're building at the end of the day, that we see a lot of these technologies as sort of extending what we're capable of using to negotiate, to draft, and all of these things are kind of brought to a new light. I think it's very exciting to think that in the past, we only had at our disposal certain language. And this technical language has evolved in a sense that it's become somewhat of almost like this moat against the rest of the world. And now with technology, this moat is breaking down. And so part of computational law, as I said from the beginning, is this ability to increase accessibility to everyone and how you engage with the law. And so to me, I'm very excited about exploring ways in which all these different types of technologies become extensions in how we want to interact with the legal space.
Thank you for that, Megan. I think that's an excellent kind of summary of what we've discussed here today, because it's it is shining a new light on kind of these concepts that are sort of age old to some extent, but now they have kind of a new way of looking at them. I'm just going to kind of finish by describing what I would consider to be maybe pillars of trade digitalization. So I think one of those fundamental pillars is the legal pillar. And that kind of touches on things that everyone has spoken about today, but it could be from the public law regimes that exist from the global level to the plurilateral to the regional and bilateral, to even at the national level, with the promulgation of various laws that actually make things like electronic documents legal, or data having as much standing as a fax, which is really interesting because in many jurisdictions, a fax does still have more legal standing than a smart contract, for example. I think another pillar is organizational. So this can mean many things. This can mean organizations from a governmental administrative perspective, but this can also mean different entities and identities throughout the sort of ecosystem, the digital ecosystem, and the tangible ecosystem that exists. I think another pillar of trade digitalization is a semantic pillar. And that kind of gets into both areas of both the more formal semantics and the logics that exist, but also into more of those lexical and ontological areas. And trade is very rich in those with a variety of different types of standards that exist. And then lastly, I think there's a kind of a pillar that relates to the sort of technical, and this relates more broadly to how does computer technology and systems and digital technology kind of come into play when we're looking at each area that relates to digitalization as a whole. So I think that's a summary of my thoughts on kind of what we've spoken about today. Thank you.
Yeah, I think parting thoughts, I suppose, are watch this space. You know, I think we've had a really interesting set of developments at the bilateral and the plurilateral and multilateral level around things like paperless trade and digital trade documentation and contract automation. I think we've got a growing awareness that data governance is it's potentially also a problem to be tackled at the kind of super regional or maybe even international sort of level. I have no idea how realistic that is, but it would certainly make a lot of sense to me in many ways. And I think, you know, we're going to see I don't know when it's going to be, but we'll see an inflection point where a lot of the tools that we would describe as being tools of and for computational law sort of come in onto everybody's laptop. And I think, you know, things like GenAI copilots are going to be part of that. I think we've been pretty busy in terms of trying to work out the private law framework for digital representations of assets. And of course, once an asset is represented by sort of a digital token, it can start to interact in these very complex computational structures in novel ways, which can have negative and positive kind of implications. I think space to watch is kind of the tokenization and thereby the financialization of everything. Things like trade finance, for example, being an obvious example. And again, that's going to have benefits and potential pitfalls and risks attending it as well. Yeah, they're the points that I'm sort of trying to keep my eye on.
Yeah, thank you for that, Jason. There doesn't seem to be any questions posted by the audience. So I'll just go ahead and just thank you again. I mean, we've had a very fruitful discussion, I think. You know, we've gone from talking about conceptualizing computational law to talking about AI, and now, you know, points that were raised on interoperability of language, and now we spoke about digital trade and event trade and the intersection with that in computational law, and that's been very useful for me, and I do think that for the audience as well. So I really want to thank all the panelists. Jason, Craig, Megan, thank you so much for joining us, for sparing your time. I know that you're in different areas, parts of the world, and you know, time is not necessarily morning or afternoon for everyone. So thank you for dedicating time to do this. I also want to thank Nicholas, who's behind the scenes helping to run this webinar. And I also want to thank the Trade Policy Exchange for helping us host this, for hosting this actually. A recording of this webinar will be available online, so please keep a lookout for when it is available, and share it with any other interested parties. And also want to thank all of you participants for attending this webinar. You know, it's very early in the morning, at least on my side of the world. So thank you for attending this. And please join us again at the Latin America webinar that will be on the 19th of July. More details will be on our social media pages, so please keep a lookout on those pages as well. So yes, thank you. And that's going to be my final thoughts.